Oh, yeah. So I got to thinking about this U.S. Code 10333. Yeah. It seemed that the requirements of the law were not important to the county or the state or any state of the United States. But as we looked through each and every document that was signed, the petition for the order of protection on July 8th of 2011, yes, that would have been a temporary order for protection. And we went through that what is it? Hang on here just for a second. Let's go through the actual temporary protection order instructions. Yes. The DVI2 underscore 015. Oh. Now, you thought it was not important for me to get notice of court hearings, the when and the where of the court hearings. Yes. But I thought it was. In fact, I thought it was a requirement of the law that you print clearly next hearing. The judge or clerk will write the next hearing time and place on the first page of the order. Now you must attend that hearing to continue the protection order. Yes. If you do not come to that hearing, the petition will be dismissed and you will not be protected by an order. Now the first page of the order says that that would well. If you don't go there, you won't have that protection. Now, this order and petition must be served on the respondent. You cannot have a court hearing where there is no service on the respondent. You can't issue a permanent protection order on August 12th of 2011 without actually serving the respondent. And the respondent must know what restraint provisions are in place and when and where the hearing will be held. Just like yourself as the petitioner, you need to know where's the next hearing going to be. Now, I know it's a small county, but in some larger cities, yeah, they probably put like a court number. You'll be in courtroom number 1, 2, 3, 4, 5. Yes, yes, yes. You wouldn't want to go to the wrong courtroom on the wrong day, and then wonder why it is that they didn't issue it. The next hearing date, time, and place. Now, on the first page of the order. Now, there's a big question. Did the petitioner know the time and place of the court hearing on July 31st of 2015? Was it accidental that she wasn't there? Now, you reissued the temporary protection order, right, without attempt of service to myself. I wanted to know exactly what signature was used of the petitioner to sign that, because if it was a signature that is not the petitioner's signature, that would be a forgery. Pooh. That would be the fraudulent issue of court orders. Yes. Then I'm thinking the ex officio superior court clerk probably had to sign it. Now, when we well, was it her actual signature? Yes. Now, check the boxes on the petition, law enforcement data, service of the order. The respondent must know what restraint provisions and when and where the hearing will be. Now, you need a pride and address, so on and so forth. If personal service cannot be made, the court will set a new hearing date and shall either require one more attempt at personal service. Yes. Now, there was no attempt at personal service. I would think that most courts would think that you attempted personal service, but what if you didn't? What if you thought, no, I'm going to wait until the next court hearing? We kind of went through that. I think that there are some RCW requirements, yes, 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 that you do have to serve the respondents, and there does have to be an attempt of service. Now, in 2011, you didn't attempt a service at all. No, you didn't do it here. No, I didn't get notice of court hearings here. No, then you reissued it. Oh, renewal of the order for protection notice of hearing. Yeah, when it didn't actually expire until 8/13 of 2012. You had all of the month of June, yes, all of the month of July, and 12 days in August before it would have expired. But you went ahead and renewed it. Yes. Now from 5:31 to 6:15, yes. There was no attempt of service. Now you would say that you served me one day before 6:15 of 2012 and you reissued it by minute order? Yes. I don't see any minute order. Yes. Yes. Now, why you used a minute order to reissue a temporary protection order instead of just the regular old service of the individual so they know when and where the court hearing is going to be? This 5 judicial days that you think is, well, somewhat at your discretion, there are the laws of the state of Washington that have requirements for due process. And I mentioned just a few minutes ago about this U.S. Code 10333. Yes. Now, I'm not the president. Let's say I was. And I found out that you didn't protect the rights. You didn't, this transferring of custody of children. Yes. You transferred the custody of my 5 sons to my wife without any due process at all. And I told you that I wanted them. Now, there's a lot of custody laws would say that if you do not serve the respondent, you cannot transfer custody of the 5 minors named. Now, let's look at this in a little different form, okay? Because I'm not in a hurry. I've got hours to do this because you just will not enforce the actual laws of the United States. And when I think about suing the federal government employees that obligated the president to have to use the national military because of, oh, look at here, federal aid for state governments. Wherever or whenever there's an insurrection in any state against its government, the president may, upon request of its legislature or of its governor, if the legislature cannot be convened, call into federal service such of the militia of the other states. We can involve the whole National Guard of the United States, invite all of them to be in Washington State, and then the 6,000 or so National Guard troops that said, no, he can't fire us, you can all be dishonorably discharged. Fuck. Yep, you can. Now, in the number requested by the state and use of the armed forces as he considers necessary to suppress the insurrection. Now, this insurrection, yes. The insurrection, use of militia armed force to enforce federal authority. These laws, known as the VAWA, when you don't protect the due process rights of the respondent, because I never got notice of court hearings in 2011, you have violated the federal law known as the VAWA, yes, and the full faith and credit of the United States Constitution. Now, whenever the president considers that unlawful obstructions, combination of assemblages, or rebellion against the authority that makes it impractical to enforce the laws of the United States in any state by the ordinary course of judicial proceedings. Do you understand the ordinary course of judicial proceedings? You know, I included some of that that literature about. Well, there's civil court proceedings, yes, and then there's criminal court proceedings, yes. Well, let's say you decided that you just didn't want to do it that way. I would say the state refusing, okay, to do the requirements of the law, yes, violates the ordinary course of judicial proceedings. We can't use forgeries now. We can't have the fraudulent use of the state court seal. We can't commit the crime of treason and not consider it an insurrection against the enforcement of the law.